Hey everybody, back with our second video for Unit 3. Today I'm just going to talk a little bit about some more of the policies and politics in the Supreme Court, how the Supreme Court can expand their own power, and some of the checks that are on the Supreme Court. Then we'll get a little bit into civil rights and civil liberties, specifically dealing with the First Amendment. So where we left off, talking about politics in the Supreme Court's power. So typically when we look at this, if you remember at the end of last video, I talked about strict constructionism versus loose constructionism, right? Strict meaning that if something's not explicitly said in the Constitution, that the government can't do that, right? So again, I gave you the example. Think Thomas Jefferson. He's a strict constructionist. Loose constructionist. Think Alexander Hamilton, right? Well, it doesn't say I can't do it. So if it doesn't explicitly say that I can't do something, then I can do it. We can kind of take this a step farther in the Supreme Court with these two terms here, judicial activism and judicial restraint. And the idea of these two things is basically how much a judge's own personal opinion on matters should play a role in their decisions. So judicial activism is basically this idea that the Supreme Court should be able to interpret text in the Constitution to serve the judge's own estimates of the needs of society. You can see that right here. So give you an example of this. I'll add these notes to the folder as well. I have a PowerPoint on this, but basically that the courts can take kind of a guardian role, like they act as like a parent or a guardian to the people. So you can see here some of the examples. So they might strike down different laws that they think infringe on people's rights. So you can see the court in 1989 struck down a law that banned flag burning. Said that that's freedom of expression. There's them striking down gun-free schools in U.S. versus Lopez. We talked about this right before we left school. And then striking down the Florida recount in the Bush versus Gore election in 2000. So this idea of activism, again, is basically just taking a more active role, that I can have my own personal beliefs and ideas. I'm going to put those into the decisions that I'm making for our country. Whereas judicial restraint is the idea that the courts should not really read into their own philosophies, personal preferences, or policy ideas. And then instead, they should more just look at what is the Constitution saying, that it's not their job to necessarily be political. It's their job to ensure that people's rights are being protected based on the Constitution. So judicial restraint, think about you're restraining yourself from doing something, right? You want to put your own personal opinion in there, but you really shouldn't. So you're going to more rely on only the Constitution and existing laws, not as much your own personal ideas of what the needs of society are. Okay, so that's pretty straightforward. I don't think it's too difficult for you guys. But if you need help, again, I will post this PowerPoint that I have on these into the files tab on Teams. So checks and balances. How is the Supreme Court's power limited? The biggest thing that we can really talk about is constitutional amendments. And it's going to sound weird because you think, well, amendments can be changed or added whenever. The thing about constitutional amendments that limits the power of the Supreme Court is that the Supreme Court cannot interpret a law in any way that would take away something that is protected in an amendment. So, for example, the First Amendment protects freedom of speech. So the Supreme Court cannot interpret any law that exists in a manner that might take away that freedom of speech from people. Okay, you can see they kind of put twists on it. Like sometimes you remember Schenck versus United States, the court deciding that they were going to say that it was okay for the government to limit speech during a time of war because it presents clear and present danger, right? So there's some twists on that, but the idea is that they can't take away anything that is protected by a constitutional amendment. The big ones that you need to know for your exam, though, judicial appointments and confirmations. The Senate basically, through its advice and consent power, they approve federal judges that are nominated by the president. So that's a little bit of a check. The president gets to choose who's going to fill that vacancy. The Senate has to confirm. So both other branches have a little bit of a say. A president could even ignore a Supreme Court decision if we talk about branches kind of having a check on the court. You might remember Andrew Jackson, Worcester versus Georgia, you talked about in U.S. history last year. Supreme Court says, hey, President Jackson, the Cherokees are right. You can't force them off their land. He says, Justice Marshall has made his decision. Now let him enforce it. And he forces Native Americans on the Trail of Tears anyways. So that kind of idea is that government's supposed to all work together. It's the role of the executive branch to enforce decisions of the court, but the president can really sort of choose not to. Same idea with the states evading and ignoring decisions. Sometimes states go to great lengths to kind of get around Supreme Court rulings. Think about desegregation with this, right? After Brown versus Board of Education, you have governors literally blocking school buildings from African American children entering them. And then last but not least, congressional acts. Congress can really pass laws to modify Supreme Court decisions and kind of limit the power of the court that way. The difference is that'd be much harder to do today. The big one you want, again, is up here, judicial appointments and confirmations, because if Congress tried to pass a law today that was going out of its way to limit power of the Supreme Court, it would basically just be seen as an attempt by Congress to nullify the court's power. Probably be met with some backlash from the media. It would be very hard for that to actually pass and happen. Okay, so big thing, what you need to know for your exam, this idea of judicial appointments and confirmations being the main check on the power of the Supreme Court, but also knowing that the court cannot actually enforce their own decisions. They rely on the executive branches, whether that be at the federal level with the president or at state levels, to actually enforce their decisions. Okay, moving on. Big idea 2 from Unit 2. Provisions in the U.S. Constitution's Bill of Rights are continually being interpreted to balance the power of the government and the civil liberties of individuals. So the second part of this unit, really truly getting into Unit 3 here, is civil rights versus civil liberties and talking about what those are. So you can see here I have both of them right next to each other. They're not exactly the same. We get them confused a lot. I get it. It's tough. Civil liberties are freedoms given to citizens as protection against government interference. So again, I'd say think liberties, think limits. They're limits on what the government can do, whereas civil rights are protections from unequal treatment by the government for possessing certain characteristics such as race, gender, disability, or sexual orientation. So, freedom of speech, for example, that would be a civil liberty. It's something given to you that the government cannot take away. Whereas if we looked at like the 14th Amendment, when we talk about how African Americans are being given citizenship and equal protection under the law, that's a civil right. So you see the difference hopefully there. I'm not going to go through all the amendments in the Bill of Rights. You do need to be familiar with them, but I think at this point most of you are. The really big ones, obviously number 1 is going to be very, very big. Number 8 comes up a little bit on the exam. We'll get to that in tomorrow's video. And it's really here with the amendments that we get into a lot of those clauses that we need to be aware of that are really what the court relies on in a lot of their decisions. Okay, so the First Amendment, 2 clauses that you need to be familiar with that are going to take up the rest of the video here: the Establishment Clause and the Free Exercise Clause. Okay, if you remember, the First Amendment has what they call the Establishment Clause in it, and a clause is basically just a little footnote, right? Something that they're going to add in to make sure that everybody really understands what they're talking about. So the First Amendment, freedom of speech, freedom of religion, freedom of the press, free exercise, right? All those different things. So when we talk about the Establishment Clause, it's basically just a little footnote that got put in that says that the government is prohibited from making a law that establishes an official religion or a state religion. Okay, so it's not legal for the United States to say, hey, Christianity is the official religion of the United States. They cannot do that. The Establishment Clause prevents that from happening. Okay. The other clause relating to religion is the Free Exercise Clause, which prohibits the government from making any law that restricts a person from freely practicing their religion. So again, the idea would be they couldn't make a law that says, hey, you're not allowed to be Catholic. No Catholic churches are allowed to open. That would be illegal. And the Supreme Court's basically over time had to debate and discuss how these 2 clauses are applied and how this whole thing is going to work on more of a grand scale. And a couple of the court cases that we've talked about, really going to focus quickly on these 2. Angle versus Vitale, I think you guys forget a lot more than Wisconsin versus Yoder because we did the moot court. So I'll start here. If you remember, in Angle versus Vitale, New York State actually had schools read a non-denominational prayer in the morning. So if you can think like in the morning, if the announcements came on and at school they were saying a prayer, this is what was happening. And so it got brought to court basically saying that by forcing kids to even be at school, which is, by law, kids are required to be at school, that even if they weren't participating in the prayer, that they were being forced to sit through it, listen to it, whatever it might be. And it challenged the First Amendment in the Establishment Clause because they're basically saying you can't establish an official religion, so therefore you shouldn't also be able to establish that you are going to be praying in a government building, a school. Okay? So the Supreme Court says that the reading of school-sponsored prayers is unconstitutional, which is why, if you notice when you go to school, we're not saying prayers in the morning. Okay. Wisconsin versus Yoder, I think you might remember that one as well with the Amish. They wanted their children to stop being educated at the age of 14, but state law said they had to go to school until 16. The court ruled that there was an exception to be made because that compulsory education law violates the free exercise of the Amish. That part of their religion required their children to leave school at that age, that the skills that they're going to be using in the rest of their life are things that they have already learned, and now they're going to basically go back to their communities and learn different trades and things like that. So the free exercise clause had been basically violated. Okay. So those are the two main religious arguments that you're going to possibly need to know for your exam. Getting into freedom of the speech and press, and this is going to be the end of the video today. Still the First Amendment, obviously, freedom of speech and freedom of the press, but three cases that are all slightly different. And you can see I highlighted one because it's the only one we really didn't get a chance to talk about in school. So Tinker versus Des Moines, very quick, briefly, you know this. Students wore black armbands to protest the Vietnam War at school, and basically the school suspended them, saying that it was not something they could do in school. They're out of dress code, and so the Supreme Court rules that the students have the right to protest the armbands, that they don't make any sort of disruption to school, and that the students do not shed their constitutional freedom of speech rights when they get to school. So basically, your freedom of speech does not go away just because you're in school. All right. You might remember, though, that in a similar case, the court rules the opposite. If you remember, we talked about in the Frederickson case, or the Bong Hits for Jesus case, as you guys like to refer to it as, and I refer to it as, that a student at a school event rolls out a sign that says Bong Hits for Jesus. As the Olympic torch is going by, he's suspended by the school. This court ruled that in that case, that free speech can be limited because the school had a policy against drug use, and that sign could technically promote it. So you can see the difference there, right? Schenck versus U.S., we've talked about this before too, that Schenk's convicted under the Espionage Act for distributing pamphlets or flyers encouraging people to basically dodge the draft for World War I. And he says that his conviction violates his First Amendment rights and freedom of speech, but this clear and present danger test becomes a legal precedent, that if the stuff that's being printed presents a clear and present danger to society, like yelling fire in a crowded theater, that you can be put in jail for that, or your freedom of speech can be limited. The last one for today, and I'm going to spend a couple more minutes on this compared to the other ones. So I apologize if you think I've been rushing, you need a little bit more clarification on these cases, please feel free to reach out to me. I'm just trying to keep the videos as short as possible for you guys. So New York Times versus the United States. In 1971, you might remember from U.S. history last year that President Nixon eventually resigns because of the Watergate scandal. So what happens is the New York Times and some other newspapers, the New York Times is just the one named in the case, get the Pentagon Papers. It's basically these papers that provide damaging evidence about things that Nixon had done that he probably shouldn't have been doing. Okay. And Nixon seeks to prevent the New York Times from publishing it. He doesn't want that information to get out. And he's going to make the argument that they needed to exert prior restraint based on national security purposes. That, like, hey, if this stuff gets out, it's going to provide gaps in our national security. It could lead to really bad things happening, right? We're still in the Cold War here. And this idea of prior restraint is basically that if a newspaper has something that they know is bad to, if it gets out to the public. So, for example, I don't know, I'm trying to think of a good example of this. If Donald Trump had something that was potentially damaging this whole coronavirus crisis, that like he had information that, 1 million people are going to die within the next month, and they didn't want that news getting out because they don't want to cause mass panic and hysteria. The idea is that he could ask for prior restraint, that the newspapers withhold that information from the public on the grounds of it was better for the country that way, that there's going to be less of a big problem, people aren't going to be freaking out. But in this case, the Supreme Court rules that the government did not demonstrate a need to exert prior restraint so that that information could be published. It's really a big win here for freedom of the press, basically showing that the government can't limit the freedom of the press, even if that information is damaging to the government itself. All right, so if you guys have any questions, I will stop there. That's the end of the First Amendment stuff. Tomorrow, we'll get a little bit more into the Eighth Amendment and the 14th Amendment, Big Idea 3. You guys let me know if you need help. Office hours, Tuesdays and Thursdays, 11 to 12:30. Hope to see some of you guys there. Have a good one.